think we got everybody, so we'll go ahead and we'll call Morris County special call meeting to order June 25th, 2018 at 1 p.m. We've got on the agenda ordinance 2018-04 budget fiscal year 18-19 second reading.
Ordinance 2018-04 Budget Summary, an ordinance relating to the annual budget and appropriations. Bid ordained by the Fiscal Court of Marshall County, Kentucky. Section 1, the following budget is adopted for the fiscal year 2018-19, and the amount are appropriated as below. General Fund, $10,532,542. Road Fund, $4,665,025. Jail Fund, $2,504,150. Grant Fund, 0. 911 Fund, $682,000. Occupational Tax Administrator, $3,060,000. ABC Fund, $345,110. And Building Inspection, $271,500 for a total budget of $22,060,327. This ordinance shall be published in the Tribune Courier newspaper by title and summary within 30 days of adoption. This ordinance becomes effective upon passage and publication.
Is there any questions about the budget?
Bring up one. I know it's not necessarily my involvement here, but the travel of the commissioners' expenses. I feel like until there's something resolved about whatever's going on, that travel expense ought to be put in the budget. And if there's some way it's resolved that there's some problem with the travel, then that the commissioners are voted in, and part of what they're voted in to do is keep maintain information about grant programs, transportation dollars that are available. All this is what these meetings are about, that these training seminars and things that they go to, that's what they're supposed to be doing, or we're supposed to be doing. And until there's something resolved with this, I don't see how we can not keep that in the budget. That's just my opinion.
That's in a form of motion. I'll second that.
I would make a motion that we add that we amend the budget right now to include that for all the commissioners' travel expenses for all the commissioners. These meetings, and it can be however it wants to be done from this point on until there's something resolved and some reason not to allow someone to travel, that it's budgeted for them, everyone to be able to travel as needed.
Second.
Under the discussion, not knowing the details, I think there's two sides to that coin. You know, just like for an example, when we had the meeting here the other day with the nonprofits, we brought in Tony and the two Murray State professors. Did anybody ever meet Tony?
That's, we had that discussion there, and I looked at
I don't
mine,
think-
and apparently I did, yes, is the answer
I
to
don't
your
think,
question. I
you know,
didn't meet
the
him, but
problem
he-
I have, I'm the one that prepares the budget. The problem that I have is that the training, if you attend, is actually good training. We have
Absolutely.
serious issues in our county. I consider giving away $250,000 to nonprofits a serious budget issue. But when we have elected officials that don't attend, Tony was the one who gave a presentation that supposedly the three of us attended. And it was
right, and-
regarding the endowment. I can tell you that there was only one of us that attended.
That is
consider-
inaccurate information.
It's not.
I checked my record,
And,
and that is inaccurate information.
The fact that, you know, I bring the instructor to the fiscal court with the endowment system that actually, I think from talking with council, that it was attempted about 8 years ago to do this. Bringing a solution to the table and then having elected officials comment that training is good, and it is good, but you got to attend. And with my budget, yes, I find it my responsibility to be the good steward for the taxpayer, because if we've got elected officials that are, you know, signing in that they're attending this training and they're not, and then they're getting paid for attending this training, I consider that a serious flaw, and I'm not going to contribute. You guys are obviously a voting member of this fiscal court. If you want to make a motion to put those monies in so that that can continue, that's on you. But I'm not going to support that type of behavior. Not going to do it.
Motion's been made and seconded.
We're under
I mean,
discussion.
there's controversy, there's a difference of opinion here as to whether that's right or not. I don't know how you're going to resolve it, don't know if there's, what's going to happen, but until it's completely resolved, my motion stands.
Well, there is a process, just so
A
that
second
people
stands.
know, and not knowing that information. I think bringing this issue to the table is enough, and you had one who admitted to it. I think is enough to at least understand that there is some flaws.
If we're in discussion, if everybody else is through, I'd like my turn to discuss and what was said and my follow-up on the information. I talked with, again, a guy named Scott Sharp who administers that training fringe. And for those folks who are not familiar with the training fringe, it's a legislative process that if the elected officials obtain 80 hours of continuing education in any 1 year, or 40 hours in any 1 year, they receive that training fringe. What was the year that was in question is 2017, where Commissioner Boland had 126 hours. I had 128.75 hours, and you have to have 40 to qualify. And when I talked to Scott Sharp, he said, and I said, I don't dispute the 2.5 hours there. I looked at, went back.
Again, I'm just going to remind you, this is.
Can I finish?
The auditor's
Keep getting
exit
interrupted.
conference is where you got that information.
Okay.
That clearly states it's confidential.
That's not where I got my information.
There's
If-
no one else that has that information.
When you get through talking and I can have the floor,
Scott
just let me know.
Sharp hasn't received anything. He's with DLG. Just as I stated in this fiscal court, but nobody wanted to listen. I haven't sent anything to DLG. It is going to be sent to DLG, but DLG has not received anything. So whatever information you're talking about, the only thing that has been discussed is with the auditors. And that information in that exit conference is confidential because it has yet to make it to the APA. And counsel, will you advise on that?
Well, yes, that is my understanding that nothing has been forwarded to DLG as.
You know for a fact, because you got me a letter from
Well,
Gregory
yes,
Ladd
I
that
did an
says
open records
there is
request.
no such thing.
And I've been advised that, by the judge, that he's had the discussions with the auditors, and they are researching it or whatever they're doing before they turn it in or file it.
The exit conference, and every time we have an exit conference, and I knew this was going to happen because you don't look at the fact that it states clearly on top of the document that it's confidential information. I take that serious. You may not, but that information is not to be released to the general public until it makes its way to the APA. That's not my standard. That is the standard that's in place. I just follow it. DLG, as I stated the last time we discussed, it is and as I sent to the media that obviously didn't read it, it is in my office under review until I get information from the auditors. But until then, it hasn't made it to DLG. And DLG, they are the ones that house the training incentive. So calling up to Scott Sharp, who is responsible over the training incentive, he may be responsible over the training incentive, but he hasn't received anything from my office.
Are you done now? Can I have the floor uninterrupted?
As long as you're not talking about confidential information.
Before any of this, the auditors or anything else, and I got the same email that you did, this was prior to that audit exit. And
What email?
If you go ahead and say what you want to say, and then when I start talking, I'd like to be uninterrupted if I can to tell the story.
What email? I don't know what email you're referring to.
Email. Before the audit exit, and this was brought forth well before the audit exit, I contacted Scott Sharp, who administers the program, and I asked him to send me a copy of my training hours, because they, at the end of the year, in 2016, he said, well, I've got them right here in front of me, Rick. He said in 2016, you had 106.5 hours, in addition to the carryovers from the previous year, which made it 146 hours. And all you have to have is 40 hours. In 2017, I had 88.75 hours of continuing education. With the carryover of 40 hours from the previous year, that made 128.75 hours. Commissioner Boland had 126 hours. We are in the top 1 percentile in the state of Kentucky of all elected officials that attend those conferences of continuing education. So in Scott Sharp's own words, if I said, I don't dispute the 2.5 hours or the 5. He said, Rick, and this is his very words, he said, you can take the 2.5 and double it to 5. You can double the 5 to 10, you can double the 10 to 20, you can double the 20 to 40, and you can double the 40 to 80, and you still got 46.75 hours if you dispute 80 hours of them. So that's word for word with that conversation, period. And that's that's my story, and we're going to find out this is very foolish, and I think political, and not only does something like this, the comments damage my ability and the other commissioners, elected officials in the state of Kentucky, to learn and the ever-changing laws of the state of Kentucky to be able to make informed, educated decisions, but it's a shot at CAECO. They have 37 and a half hours that they give right up here at Kentucky Dam, and there's a girl sitting at the door when we go in there, herds you back from lunch, signs your papers when you go out. That's 37 and a half of those 128.75 hours and 126 for Commissioner Bowling.
Didn't cost the taxpayers a dime.
And we don't travel anywhere to get that. We go up there, and like I say, there's somebody sitting right there at the door. So to insinuate, to imply that we don't have 40 hours, not a single penny of taxpayers' dollars are compromised, period.
Let me be clear once again. Scott Sharp hasn't received anything from my office. So when you're talking about hours, I don't know where those hours came from. And clearly you don't have all the information. There is no question under this administrative review that you don't have however many hours you say you have.
What's the point then?
Never has it been a question. The question is those hours that you do have, there are some discrepancies.
And I didn't
it's
deny
not,
that. That's what I told him. I don't
it's not a
dispute that whatsoever.
discrepancy. It's not a discrepancy that an elected official makes a mistake.
There are things come up, and everybody in there.
It's been abused.
I'll let you.
And
Oh, yeah, it's been
I'm not
abused.
going to give you a penny because I've seen enough. I'm not, if there is a level of responsibility for accountability on elected officials, and I would expect the same with me, it's right here. And you're asking me to look the other way. And that's where I'm not gonna do that. I'm gonna do what I was hired to do, and that's to make sure that this is not abused. And I can tell you, you can ask anybody, that the training incentive can and has been abused, not just from this county, but across the state. It's one of the most abused if you look at it, because the accountability is not there. They need to change, and that's above our level, but they need to change how they implement that program. Because at the end of the day, it's taxpayers' money. Not yours, not mine. It's taxpayers' money that we're supposed to be responsible for. And when it's abused, and in my opinion, grossly abused, because we have forgotten, those that are involved have forgotten who actually pays the bills. And I'm not going to support it. You guys have the legislative authority to override me. That's fine. You do it. I'm not participating in it. My vote will be clearly a no, because I'm not putting monies into a line item when I know that there's discrepancies. Now, if DLG wants to come out under Section 6 of that statute and make a decision, that's on them. But at my level, my responsibility, I feel that that's my responsibility. I'm not going to continue to give monies to elected official who I think abuse it. Not going to do it.
If we'd have had 38 hours, that 2.5 would have made a difference.
At the end of the day, DLG cuts the check, not the fiscal court. So it doesn't. When you have that argument, DLG is the one that cuts the check. So.
Again.
That's my
Again,
comment on that.
There has not been one single penny of taxpayers' money, not one single penny of taxpayers' money again that has been compromised in this situation. Not one.
I disagree.
Until there's an official report of some sort that comes out, that can be reviewed by everyone, my motion stands.
My second stands. Question on the motion.
There's a second to amend. What was the motion?
And then the travel expenses and, whatever's in there. I've got travel expenses in my line item, I assume, but they'd put them in at the same level for all three commissioners.
And what's that amount?
$5,000.
$5,000 for Commissioner
Same thing it's
Bolin
always
and
been.
Cock. So it would be 10,000. That would reduce reserves, unless you all have another place.
Where are those monies coming from?
Amend them in.
She just said reserve. I thought I heard the
Which
treasurer say
reserve?
reserve. That's what she said.
You got the budget. I'm assuming you looked to see where the monies are going to come from.
She just said reserve.
He's making a suggestion.
Okay, that's a pretty good suggestion, I guess, unless we want to take something else
Which
out.
reserves?
It's up to y'all where. We don't care where you find the money. It's got to go back in the budget.
And the budget also has to be amended for the training fringe, because that's a legislative thing. If you obtain 40 hours and you get that piece of paper,
That can be amended. We already
does not
discussed
have a choice.
that. That can be amended at any time.
Mhm.
DLG sends that letter out.
Sure, and that's what Mr. Sharp said. Yes, sir.
Where's the money coming from?
What are the general fund reserves?
General fund reserves, as presented, are at 60,695.
How much?
60,695.
That should answer your question, where their monies are coming from.
Then it could be amended to come out of reserves, general fund reserves.
We'll do a roll vote. Bob? Johnny?
Aye.
Rick?
Yes.
And I vote no. All those in favor say aye. Motion passes. Any other questions about the budget? Is there a motion to pass the budget?
Go ahead.
Go ahead.
Yes, all of these nonprofits, they cannot wait for a 2 or 3 month investigation by these so-called Murray State professionals that's going to be reviewing this. I think they need to be paid immediately. They're very important to them. They can't plan their budgets around this. So I'll make the motion that we immediately disperse these funds for the nonprofits.
We
And I
haven't,
have a list.
we haven't approved the budget yet.
But in that budget last year, and I would like to expound on that, I agree with Commissioner Bolin, not wholeheartedly. We had a list last year that we approved, and we've cut that funding $22,300, and in this proposed budget, there's $200,000 in there.
Hang on a second. Last year's budget, we already stated this, and I want you to speak accurately. Last year's budget had how much amount in it? 205?
$205,
It
$205,000
ended up
as of July 1.
$222,301.
You need to speak accurately. Last year's budget had 205,000 in it.
We
As of
paid to
July 1.
nonprofits last year. After the amendments, the final budget ended up at the end of the year with $222,301, period. Is that not accurate?
Actually, it's not.
It's
There was
not.
an additional 30, there was additional $10,000
Well,
added to that.
Look at budget draft number 1, look at budget draft number 2, and look at budget draft number 3.
These are budget drafts for next fiscal year. They have nothing to do with this fiscal year.
In our budget draft, we have what we had last year. It's $222,301.
As of February 18th, if you'll notice on that column, that's the date that is for.
Correct.
Yes, so as today, it is not that same number.
Okay, well, I've just got a third draft to put in front of me here 30 seconds
And I don't
before I walked in.
update all of those historical columns every time.
Oh, okay.
You'll
Well,
notice
no
each
wonder
draft, that column stays the same.
And just so that you're aware, that is in compliance with statute. I just want you to speak factually. I'm
I'm
tired.
very factual. You can't be more accurate than that.
She just advised you weren't.
I disagree.
The issue today is to approve the budget. There's $200,000 in this line item for nonprofits.
And we've stayed at 197.
I'm sorry?
We have 197 appropriated for our nonprofits, where you set it at 200.
Yes.
So we're
it's-
3,000 underneath your proposal.
What I would like to see is.
I don't know what you're
is-
talking about. 200,000 is what we budgeted for.
What I would like to see was, in adding to, I guess maybe in addition to Commissioner Boland's recommendation to itemize out this $200,000, because there's, as we talked about when the people from Murray State were here, there are a couple of groups on this list that can't go too much without they'll close the doors. And some of them are not in great need, but I have a list that I would like to submit very similar to last year's list, and I will read it, but with one stipulation, that we ask these groups to meet as one with the Murray State program, with the fiscal court setting up a series of dates so they can do so and make these, if this works, great. If it doesn't, we've still got these itemized, and these organizations can go ahead and prepare for their year as we're preparing today and set up their budget. But two of these groups, the Calvert Benton Senior Citizens and the Hardin Senior Citizens, cannot survive a month and a half without those funds. We're telling, and I'm not going to be responsible for having my fingerprints on the padlocks of those doors. Those senior citizens programs are very important to us. Not only that, the 50 seniors that they feed Monday through Friday with a hot meal that's delivered to their door. Some of those people, that's the only contact they have with the outside, and not all of them. Some of them have relatives that visit, but I think it's an important program, and I'm not going to be any part of that. And that's what happens. That's what happens with those. I attend the board meetings. I know their financial situation, and they cannot make it. Some of the others can. The proposal that I'd like to make, with the Marshall County Exceptional School receiving $5,000, very similar to last year, actually a little under last year's allocation. Exceptional School, $5,000. The Veterans Van Support Group, $3,000. Haven of Hope, $2,000. Hoop Fest, $7,500. Marcella's Kitchen, which we gave $10,950 to. Basically what they asked for is enough funds to pay their electric bill to keep the lights on, and their electric bill last year was $13,000, so I'm proposing to raise that from $10,950 to $13,000 to meet their needs. The Benton Calvert Senior Citizens, $92,500. The Marshall County Need Line, $35,000. The Wheelchair Ramp Ministry, $3,000. The WACPAC Utilities, $2,500. The Hardin Senior Citizens, which was $37,550 last year, they think they can make it with $30,000, which frees up some of the monies to go around. And also the Marshall County Children's Arts Center, which was not included last year because of the school shooting. They have already secured, made arrangements, and it's in place now for security for the children down there after the school shooting, and that was about $3,200, and they did not have that budgeted, so it's a hardship on them. So they asked for that monies, which I proposed to put in there $3,500 for a total of $197,000. That leaves $3,000 in reserve for whatever. And again, with the stipulation, after we itemize where this money's going within the budget, what's in the budget, that we require these groups to meet again as one with the Murray State program, with the program set up, the fiscal court setting up a series of dates with these Murray State people and making available the see if this thing can work for them. And I'd like to put that in the form of a motion.
Second that motion.
discussion?
Does anybody have any problem with that, the program? I mean, it might work for some. It's certainly worth a try. I know some of these other organizations have other sponsors and so forth. And as I said before, this community, there is not a community anywhere in my mind that is more giving and caring than the people of Marshall County. And sometimes we just get, especially with what happened in December, it just seems to get, harder and harder in these fundraisers and so forth. But I have no problem with these guys. I've known Bob Long for 45 years, and he's very good at what he does. I know sometimes this works and sometimes it doesn't, but certainly I have no problem with these people at least offering assistance that turn these organizations or point these organizations in the right direction. And if it might be successful and it's not, but if it's not, none of these organizations fail, or the senior citizens programs don't fail. And them, like us, they need to make preparation. They're in the budget process too, and their expenses, and they kind of need to know instead of at the end of the year, they need to know at the first year the monies that are available to them.
After the
This Jeff, I got a quick question for you. This is the second reading of the budget for approval. I just want to make sure that we're not outside the bounds of that as far as the special meeting, because we're going into giving specifics on these organizations meeting with the professors, and I can assure you I didn't hear anything as far as documentation, what process. I mean, there's a lot to that. The administration, the carry out the administration of the fiscal court lies on my office, and stating numbers is one thing, but the administration and how that's going to be played out, I think is going above the budget. We've had
Okay, I'm just thinking back through it. He basically, the motion is, I wouldn't say conditional.
No, I mean, we just asked them if,
Well,
and I'm not trying to mandate anything to anybody, but I asked Jason these same things. I don't know if you talked to
outlining these
Jason.
in the budget is what I
Yeah,
believe
putting
I
them
heard in the
budget's
motion.
one thing, and
Fine.
your follow-up is two different things.
That's just my thought about something that's good. We could utilize these people, scratch all that then if there's a problem there.
Yeah, well,
I just want to
it's-
itemize these lists.
And I think what you're saying is good, but it's a pretty broad stroke. And
Okay.
in order to bind your budget up with that, it could get complicated.
Okay, just with, my motion is scratch that. That's just a thought that and my own personal thought that if we can help these organizations better themselves through a program, that's great. That's a discussion for another time. That's great. My motion is amended to say the list that I read totaling $197,000 with $3,000 left over for incidentals, and itemize that so that these organizations can continue to function and prepare their budgets for the coming year.
Under discussion, I'm just going to make it clear that there are other 501(c)(3)s. You're not capturing all the 501(c)(3)s in the county. You're limiting to last year's line, which we all agreed last year was the first time we did this. The goal is to get it out to all the 501(c)(3)s. And I get it. I know what's going on here. My administration is trying to put something in place for these nonprofits, because handing them money, some of them, that's not going to fix their problem. The goal is to help them. And I think by the fiscal court's attempt to change the administration process that we're trying to put in place goes beyond the budget. And
This process with Murray State should have been started 6 months ago, so we could get these funds to them at the right time.
I'll tell you when it did start. It started long before 6 months ago. It started when we sat in Tony's presentation. Some of us did. and we saw the desperate need to bring that organization to this county.
But the
If
first
you look
fiscal
across
court
the
heard was
state,
last week.
how many other elected officials actually saw that opportunity, we did. And obviously, I found out that it was something that was tried and attempted 8 years ago. So there's been an initiative to help these organizations instead of just throwing money at them. Some of them. The other ones are out there actually surviving. And I think as leaders in this county, we need to have those discussions. We need to sit down with those organizations. None of these boards, a few of them members have contacted, and we explained to them that we got to pass the budget and we're going to get the process started. And with Tony and Peter and Dr. Long, today is the 25th. This budget can be approved, and that process would start. It can be done fairly quickly, and those organizations would be put through an administrative process that would benefit them for the long term. I just think the approach here is a desperate approach. I haven't heard of anybody that's going to shut their doors. We discussed that last time. I would think any organizations that's going to shut their doors, they would come up and see me. Nobody's came by and saw me.
I said last time, they have contact, I'm sure the other commissioners, as a matter of fact, I know the other commissioners have been contacted, and we are their representatives in their voice, and we voiced our concerns, not only today, but last time. I agree 100% with the program. I'd agree with Commissioner Boland. The timing is very poor. If next year, if we want to talk about this after, and I had that in my original motion before I made it because I feel exactly the same way. If this program works, it will be a super duper program. And we want to make every effort to help these people help themselves. And if it works, fine. And that's why that comment about the group from Murray State was very, very, that's why I made it, because I think it's important that we do everything we can so that they can help themselves. And but it is, as Dr. Bob Long, my friend Dr. Bob Long said last Tuesday, it is a marathon. It is not a sprint. It's not going to happen overnight. And thus, I agree with Commissioner Boland, the timing is very poor to, with 2 weeks, we're not going to teach them something in 2 weeks or a week now, but my motion's still on the table with the second.
I think the other concern is that as taxpayers' dollars, we should know where those dollars are going. I haven't seen one request for taxpayers' dollars in the form of a project, a summary. None of that information has been given to to my office. We're giving dollars out to these organizations with no documentation to support those dollars.
We had documentation last year, and I think our attorney advised us that the first question that has to be answered, correct me if I'm wrong, Jeff, that these dollars, when you're spending taxpayers' dollars for this purpose, the number one question has to be answered, does it serve a public purpose? Is that correct?
Okay,
And
and that's a great question.
Anybody,
If it does serve a public purpose, do we know today that all these organizations are actually meet the standards in compliance with the IRS as far as the 501c3s? And if they're not,
Well, all I know is
taxpayers.
what documents I saw up through last year.
right.
And they all
were
appear to be
good.
public organizations. Now, let's take one step back. This whole program has been in existence for a long time. Several years ago, there had been some issues in other counties, and so I sat down, we researched it, wrote an extensive letter to the court before any of you all were even here that outlined basically the public purpose definition as well as earmarking, what we suggested, because then there was a whole array of organizations that would come show up on a night and they would make application and those monies. So what we suggested was to determine it was public purpose and earmark those funds for that, for whatever they had proposed. The program has progressed some, and as of last year, the grant application, that's the documentation that I'm aware of. So the whole public purpose thing appears to be satisfied, but like, you can never have too much documentation on those issues. But, by what I've heard, it appears that you're guiding these monies back towards the same ones that you were approved last year.
Well, I think there's
But-
some new ones in there, too.
But there've been no new applications, just as you said, and no
That's
proposed project.
not entirely
I
true.
think there's some-
The Marshall County Art Center was a new application. They provided each commissioner with a folder and
Okay.
their request.
Yeah, I haven't
because
seen
of-
that.
Because of the
Well-
$3,200 they spent on security as a result of the school system, their school children in there, and they did that, and they didn't have that budgeted, so they were over budget for that, and thus they added to the list. But I challenge anybody to go down that list right there and tell me one entity, I'd like to hear it right now, if it does not serve a public purpose to the people of Marshall County.
I'm not intending to challenge any of
Yeah,
that.
I know
My
you're
purpose
challenged.
is
I don't
to
think
state,
you
you all
can.
you got to determine the facts.
Here's the thing. All right, just a case in point why we do these things meticulously. Bring up the Children's Art Center. Nobody's arguing that the Children's Art Center doesn't meet a public purpose or that it's not a good organization.
My point.
But what I will tell you is that the audit reports years past have stated that there's no contract. Now, I know council advised the fiscal court that we can put it in our minutes and the city of Benton can put it in their minutes. But what did the exit conference state? You two read it. You sat in with it. Knowing what the auditors stated about that contract, you still want to give dollars, and correct me if I'm wrong, if we're giving dollars, taxpayers' monies to organizations that don't meet the administrative requirements of the fiscal court, I think that we have to look at that in a more detailed scope. Right
doing that,
now, we haven't heard that from the auditors. We sat down in the audit exit interview, and that was still an issue as audits in the past.
Obviously, and I agree, obviously, if that contract would have been done when that relationship was created, that would have been the best scenario.
Right.
When I dug into it, the best I could do, because CAECO didn't have anything to back it up, the best I could do was get the minutes from this body and from the city to show that they had at least voiced an opinion to support it. That's the best that's available. I can't create anything else.
And with that information was given to the auditors, and you two sat in the exit interview. That has not been resolved yet.
And I didn't know whether it had or not. And like I say, I don't. There's nothing else. I don't have anything else to give them.
I understand that, but the question is, we're making decisions today when we haven't received anything. And when I say we, as far as all the 501c3s that may want to put in an application for these dollars, and making sure that the organizations are within standing, not that they meet the public definition or the constitutional definition that we discussed, but to make sure that everything is done correctly administratively. I just think that this is, and I get it, I know what's going on here, but the responsibility is to make sure that we do a detailed administrative review of all the applications that are sent in, so that we do catch any errors, or we do find out that if the auditors state that we don't have a contract, or the minutes that are supplied aren't enough, it doesn't meet what they're talking about, well, then we get into the areas we're giving dollars, taxpayers' dollars, to an organization that doesn't meet a standard. And without that administrative review, I think we may be putting ourselves in a position.
We can
But
always
that's my
amend the
opinion.
budget if that's the case, and come to find out that my motion stands.
I met with the auditors, and there were 12 discrepancies, and there was nothing in there about our nonprofits not being in compliance, was nothing.
It's not in there as a nonprofit, Johnny.
My motion stands.
My second stands.
I don't believe this has had anything to keep or to thwart that review that we're planning on having over these, the administrative review over these nonprofits. Anyway, I don't believe that's the situation. I think I think we're trying to at least show that that those dollars will be available if they're needed. I don't believe I think that's what's trying to be done here, but I'm not sure it's it's being done as well as it could be, but I don't believe it has anything to do. All of those would not necessarily have to get their funding immediately. There's just one or two that really do need to probably be propped up. The others, in order to review their budget, they need to know that we're going, as long as they meet the standards, we're going to support them.
And I think you answered the question I got, is that we're putting dollars in the organizations without an administrative review in place. And the process that we're doing, we're actually going back. We're going backwards here by doing this, because we're giving dollars in a line item that we have no review, none. They may have different projects.
But
I mean,
again, the point was brought up. I mean, if we had completed this, or I know you said it started, but the actual contact with the nonprofits and these dollars have been discussed just over the last few weeks, and maybe a couple of months, and that's wasn't enough time for them to prepare.
we're prepared to, as soon as this budget is approved today, we're prepared to start executing that administrative process.
I understand that. And that would be.
And I think that is as elected officials, that is good administration
have no problem with
for
that.
taxpayers' money.
That letter from the county was sent out May the 2nd, one day after this budget was presented to us from the Budget Committee, the first draft of the budget as required by law. The letter was sent out, so the process, the timing is horrible on the thing.
You're not talking about my letter.
No, I'm talking about what Brad Warren sent the nonprofits on May 2nd.
Okay. Clearly you didn't.
After the budget was out.
Did you read the application for this fiscal year that we're in right now? In that application, that administrative process, all those agencies that we gave money to had to give us a summary of, did they spend those dollars on what they told us they were going to spend that on? That letter that you're talking about.
I've been told that at least some of them have reported to me that they've presented that to your office.
Yeah, yes, but what I'm saying is he's saying that letter is tied into this budget year. It's not. That's the administrative process that we put in.
Poor.
The fiscal
we
year
commented
starts
earlier.
in July. We sent out in May, and it clearly states, it even states on there that receipts not to be received in a certain date in June, because we're on the July 1, the end of June. The letter that was sent out was for this fiscal year, and you're getting that confused. You obviously didn't read it with this budget that we're talking for next fiscal year. That's what's frustrating on the administration side of these tax dollars. We're supposed to be good stewards of these tax dollars, and that letter that was sent out was consistent with last year's application.
Motion stands.
Roll call vote. Bob?
Aye.
Johnny?
Yes.
Rick? I vote no. Motion carries. Are there any other questions regarding the fiscal year 18-19 budget?
I don't have any.
So everything you voted on up to this point, just clarification on my part, are amendments to the budget?
We haven't even voted on the budget, correct?
Okay, just want to make sure everybody's straight on
That's
that.
the amendments be made to the budget before we vote, to save time
yeah.
instead of.
Yeah, once you Yeah, once you drop the hammer, you can't amend it.
That's why this discussion was there. We are proposing, I am not totally satisfied with everything, but I can live with everything with those two changes. And I've already stated some of the other things that are proposed in this budget. I've already made my comments a couple of years ago, and I lost. I was on the wrong side, and democracy took place, and I was in the minority. So like I say, I've already made my stance a couple of years ago on that. So, but with those two items, I'm relatively satisfied, and I can live with it.
Just so I'm clear, what are you all expecting to happen on Monday, July 2nd, as far as those payments?
My motion, it was
Well,
to.
you put them in a specific line to change in the budget. The administrative process is carried out by me. So
That was in my motion, because I do not want those people to fail and not get a check. Last year, you gave the option that you could disperse the entire amount on about the middle of July after everything
I
got
didn't
up.
give
We
options.
didn't-
I
we
can't
didn't
do
give
that.
Well, you told me you could do it either way, and on July, the middle of, but you needed a couple of weeks to
Yes,
clear.
we
and
cut those checks on July 12th last
I understand
year.
that. Some chose to do it. I think probably, you tell me how you did it last year. Did they all
We
go
cut
out
those-
immediately?
We cut them on July 12th
Okay,
last
so
year.
every one of those got July 12th. I
Not
don't,
everyone. There was one that wasn't cut until the following week.
okay,
But-
well, everybody got dispersed instead of monthly or so forth. If there is a problem, I have, if there's some of these organizations that, think that this program is beneficial or starts
Well-
being beneficial, we can always go back and amend this thing.
But
Just,
I guess what I'm asking is, I can't issue any payments until I have a budget adopted.
Right.
Once that's adopted, I need to know, I have clear motions to pay the bills or to pay this
That-
particular item or that particular item.
That's-
But I
my-
don't know which of your list, is your motion, is the approval
thought I
from
was
the
clear.
I
fiscal
haven't
court
even
for me
seen
to
it.
pay out all of those as soon as possible in July?
Yes.
that was
That
the
wasn't in the
intent of my
motion.
motion. Then to meet with the groups got a little, I think it's a good program, and I think we all think it's a program that at least is worth trying. And so I've amended my motion to strike that, but that list right there, yes, I would, they came to us last year, each one of those groups sat right over there in those chairs
I think-
beside Jeff, and made their plea for these monies. They sold every single one of us on that. We were unanimous when we voted for this list, with the exception of the security that went in as a result of the shooting on January at the Exceptional Arts Center for $3,500, which they've already done, and that wasn't a budgeted item. So they're exactly the same. They sat over here and sold the entire fiscal court unanimously on the need that it served a public purpose. They qualified for the program, and it's a much better method, as Jeff clearly stated, than the money giveaway night that used to be, and that was probably been 15 years ago.
Right.
20 years ago. And, not that the Cub Scouts and the Girl Scouts and the Boy Scouts are not a good organization, but you just, it
Look.
got out of hand.
this meeting today is a special call meeting for the budget. We're getting in, and I think we're getting outside of the budget. This is getting ridiculous. There is an administrative process that is to be carried out by my office. What you just took was the $200,000 and put it in a line each for these organizations, which we haven't seen the list. You're going to have to give us a list. The fiscal court is, and then those dollars are going to be set for those organizations. That's what you approved. We have yet to approve the budget. The carrying out of those dollars is set within my office. And as I've stated before, there is an administrative process with Tony and Dr. Peter and Dr. Long when you start getting into that area, you're outside of what we're here for today.
No, I'm just saying that's a good program. I amended my motion was amended. I understand that. I just wanted to, that was strictly a comment. And after I amended my motion, that was a comment instead of, I'm not, I agree. I have no problem with that. I think it's a program that could benefit some of these. Hopefully it works on all of them. That's yet to be seen. My motion stands. But we need, in this discussion, the 4 people that vote on this budget are going to put it in a form, so hopefully we can all agree and pass this budget. And it takes a 3-to-1 majority, 2-2 tie won't get it. Hopefully we're going to sit up here like adults and discuss this and come to a conclusion where at least the majority of us are happy, and that's democracy.
Well, there's not a
I'm
motion
sorry.
pending.
No, there's not.
There's not a motion on the floor.
The motion is already
Yes,
passed.
I have made a motion,
Yes.
and there's been a second.
No, you've already voted.
You already voted.
Okay, well, then there's not,
There's not a new motion.
okay, I agree, okay.
I'm sorry, I don't
But
mean to
we're
be dense,
back-
but I'm confused to what was
That was to
approved.
add those numbers in to the
They-
budget.
well,
plain and
those-
simple.
Plain and simple.
Those numbers are not, the $200,000 was already in the budget. There was no
Correct.
need to amend anything
What
to
we
it.
are amending, we are itemizing those dollars, breaking them down exactly as we did last year, so that these organizations can prepare their budgets for the coming 12 months, just like we're doing today.
And
I'm-
the motion's already passed, but the
Right.
problem with that motion is that we don't know what those dollars are going for.
I'm satisfied.
Well, what are they going for?
Okay,
I mean, I think that's a fair question. What are those dollars going for? Because I heard you say the Veteran Support Group, $3,000.
Kind of getting
They weren't-
off the subject, we're here to
They weren't
approve the
prepared for
budget.
$3,000. What are those dollars going for? These are
very- I'm
taxpayers'
very-
You
dollars.
don't know where Hope Fest money's going?
I'm very
The
comfortable. I'm
applications
not
that
gonna
were
sit
filled
right
out
here and
last
dance
year
and
stated
dance all
as such
day and
what those
argue.
dollars are going for. What are
We've had
those
a
dollars
motion that's
going
been
for?
made in a second, and we
We,
voted, and it's passed.
the answer
Let's
is,
go.
we don't know.
No, we know. You're the one who don't know. We know exactly where they're going.
Then where are they going, Johnny?
They're going to organizations that serve a public purpose and benefit the citizens of Marshall County, period.
What projects? We don't know.
What is Hoop Fest? You don't know what Hoop Fest does? What kind of project do they have to have?
Where's the $7,500 going?
Going to
Hoop
Hoop
Fest
Fest.
has a $1.9
Yeah,
million
we know that, but
economic
where are
impact.
the $7,500 going?
It's going
these
to
are-
Hoop Fest to put on Hoop Fest.
Okay, without an application for a project that outlines where those dollars are going, where are they going?
The motion has been made and second, we had a roll call vote. Let's
Move on.
Is there a motion to accept the budget with the
With-
two amendments?
with these 2 amendments itemized, and we'll make sure this is perfectly clear, and we're itemizing those nonprofits and that $200,000 as stated here. Would you like a copy of that?
yes, I'll need one of those,
Okay.
please.
I think everyone's going to need a copy of
Okay,
it.
well, everybody can make you some copies right here. I've got them kind of scribbled in my handwriting, but at least I can read it. I hope everybody else can. It's not typewritten, but it looks legible to me. I tried to write a little better than I usually do. But I will, you can make some copies, or Des can make some copies there, and the others are self-explanatory, the expenses. And yes, I will. Des, you want to?
Hang on. Self-explanatory. What does that mean?
I said the other expenses are self-explanatory. We've already voted on that.
I know,
Dance all you
I'm the
want
one
to.
that carries out the administration of the fiscal court.
By yourself.
Define self-explanatory if I haven't seen a list.
my understanding right now is that list sets out names of organizations and dollar amounts.
And dollar amounts.
Is that
We've
correct?
itemized that
That's what I got.
$200,000,
Well,
yes.
and you're offering that document to support the record for this court and what you've, for the motion you've made, it's
We have
been
made
passed.
the determination that they serve a public purpose for the taxpayers we represent, as each of these
No, I mean,
entities
past that,
said-
that gives you the name, the identifiable organizations and the dollar amounts
Yes.
yes.
for her. Okay,
Within the 200,000, matter of fact, $3,000 short of the $200,000 for, there may be others in there that explain that they weren't given the opportunity to come this year to do so as they were last year. The rules were changed and at the end, but I'll be glad to, I'll get that to you, Emily, after the meeting. And you need it now?
I need it. I'd like to
Okay.
see it.
Don't mind or yours?
No, that's good. I got 3 or 4 here, but I just tore the bottom off where we didn't want to talk about the participation in the Murray State program, but that's exactly as I read off. It's exactly the same, and what you see as I read off and explained when I made my motion, Marcellus Kitchen, $10,950. They asked us last year for their electric bill, and that was, this year, it was $13,000, and so thus, we put the $13,000 in there based on last year's, and that's what they asked us for, and that's certainly reasonable.
I want to make sure that where it says here, Haver of Hope, is that Haven of Hope?
I don't know, maybe.
I mean, if we're
You
going to
get-
be
you
giving
get-
them
you-
money.
You get the jest, you should know that. Yeah, that's Haven of Hope, yes.
You ready to approve the budget as amended?
I'm ready.
Make a motion to approve the budget as amended, Judge.
Second.
All those in favor? Bob?
Aye.
Johnny? Rick?
Aye?
Motion carries. We have on the agenda the ordinance 2018-06 amendment to the administrative code, second reading. You got that, Jeff?
I got a one-page,
That's the one amendment that was changed last meeting.
on the,
Section 5.
yeah,
5.51.
5.51.
Basically, it's.
Yes, section 5.51, expense reimbursements. The
Bob one.
subsection 3, travel, county officers, the county offers a corporate rental program through Enterprise, Hertz, and county-owned vehicles for travel. These methods are preferred. Department heads and/or the appointing authority may offer to pay mileage at the federal government rate to use a personal vehicle if it is deemed more cost-effective. Alternatively, the employee may drive his or her own vehicle and receive mileage at the federal rate for miles traveled. And as the page that you've got sets out the delineation in red.
That's the one Jason and I.
No, that's a different,
Oh,
the one you gave me is the same.
okay, I wanted to make sure that's identical.
Yep, it
Assistant
looks to
County
me to be
Attorney,
identical.
When he put it in the proper order required by KRS,
Yes.
just wanted to make sure that was the proper, he assured me that it was.
That language right there is what the court discussed last
Right,
meeting.
I just wanted to make sure that it was the same, and it is.
Yeah, I
Thank
believe
you.
that is identical to
Thank
what
you.
you and Jason discussed.
Do you have
Good
this
deal.
with the changes?
Okay.
And that is section 5.51.
5-1.
A3.
A3.
Mhm.
Okay, and that's right.
Do you want to go through that? He's got them all.
Oh, for the second
It's-
reading.
It's a second reading.
All right. Yes, the new number will be 2018-16. All the dates will change. And on page 9, as set out in the, in this document, it's Coroner Property Valuation Administrator. It takes out Surveyor.
We want to do these individually?
Hmm?
We do these individually or as a whole?
I'm just going over the changes.
Oh, okay, okay. I didn't know if we,
The changes as were in the first reading. This will be the second reading.
okay.
On page 16, the language would be changed. That would be under the budget preparation procedure under
Where's
section.
that, Jim? Where are you now?
Page 16,
Page 16,
Okay.
section 4.1A,
Okay,
and the term assistant treasurer is added into that paragraph.
okay. While we're there,
And I've been given, I assume everybody else has got a copy, there another proposed section, section 4.1A, and the annual budget preparation process shall be administered by a budget committee consisting of the county judge, county treasurer, assistant treasurer, deputy judge executive, and/or county administrator, county attorney, and one commissioner as selected by the fiscal court, with the county judge breaking a tie vote if necessary, and taking out working with the county judge.
Can you state who that came from?
I received it from Jason Darnold, who said that he and Dr. Cock met Friday and put these.
Friday for an hour and a
put
half
these
to put it in
together.
the correct form, yes. And
I received them this morning.
I gave one that Desiree was not there. I put it in her chair at 8:35 this morning or something. And if we need more time to discuss this, we meet again Friday, and I have no problem with that, so everybody's comfortable with it.
what you just read will amend section 4.1A.
Right. What you all had in the first reading just included assistant treasurer.
Right.
This is quite a bit different.
Right.
As I just
And
read.
again, if anyone wants more time to study this, digest it, and needs more time, we meet again Friday, so at 4:30, I understand. So I have no problem with giving everybody ample time to read it in this form.
I'm competent to listen, and
Okay.
so I don't need till Friday.
You want me to go through,
Sure.
all right? First reading. On page 23, under section 5.3, job classification, the section D, job classifications and pay scale are set out as read the other, which I guess these would be minimum pay scale.
No, it's minimum, midpoint, and maximum. All three are listed.
Okay,
in there.
yeah, they're all three listed, I'm sorry. And under section 5.4, under applicants, and each applicant shall complete and sign a standard written county job application form, and each application shall be kept on file for at least 2 years, which is the new language. No, 1 year is the new language. It was 2. All applicants shall sign a release authorizing county to download and review the applicant's Kentucky driving record or driving history record for the state in which the applicant is licensed for a criminal history background check along with drug and alcohol testing. On page 26, under section 5.41, section selection and appointment, each applicant shall complete and sign a written county job application. Of each application shall be kept for at least 1 year. A resume or curriculum vitae may be attached to the county application. Page 27, section 5.15, methods of filling vacancies. That language is well changed to 1 year. Page 29, section 5.23, D. If an employee resigns, retires, take out or changes employment is terminated. No. put in is terminated or changes employment status from full-time to part-time, they will receive 100% of unused vacation and compensatory time paid at the regular rate of pay. And take out, if an employee is terminated from their position, they will not receive any pay for unused vacation time. That language is stricken. Section 5.24C, the medical reason is changed to medical reasons. Page 33, section 5.27, county administrator is changed to deputy judge executive. And under 5.28B, same thing, county administrator is stricken, replaced by deputy judge executive. And I think the reason for that suggestion is we do not have a county administrator. Section 5.3, civil leave. Under B, the employee will be allowed to keep pay received for serving on a jury without deduction from full regular pay. That's strict, the word salary is stricken. 5.32, overtime compensation time. County pays not exempt employees time and a half for all hours earned over 40 hours in a work week. Earned paid leave, including sick vacation, the holiday shall be considered earned hours in relation to overtime pay. All overtime shall be approved by the department head or appointing authority. That is section A. That's all new language, or the new language is included in that. B, non-exempt and exempt employees, the language that earning less than $913 per week or $47,476 per year shall have that's stricken, and then shall have the option to take compensatory time in lieu of overtime pay. And the new language at that point will be, this election shall be filed with the Human Resource Director. Compensatory time shall be earned at time and a half of hours worked.
So let me, Counselor, let me ask this question. These changes were made last year and in anticipation of the law change, which the administration thought was coming down and never did come down, so we changed it. Now we're changing it back.
I think that is
Is that right?
to become,
Yes.
yeah.
Well,
Right.
let's
Okay.
be clear,
Okay.
it was brought to the fiscal court, and the fiscal court approved that, yes.
Oh, I have no problem. I'm not critical there either. I'm aware of what happened and what we thought was coming down, and we were trying to get ahead of it, and I agree 100%. That's, that we need to change it back now that didn't take place in Frankfurt.
And then under section C, that paragraph is changed to match the language of pursuant to KRS 337.285, section 5, subsection A1 and 2, and that language following is to match that statutory language. Section D, and the same thing, pursuant to KRS 337.285, section 8, subsection A and B. That paragraph is modified to reflect that same statutory litigation. And the last paragraph is changed to paragraph E to make it match the others.
C and D are actually new language.
Yeah.
Completely.
Yes.
Yeah. Okay.
Entirely new paragraphs.
Yeah.
Which is, what it is pulling the language pertinent to that out of those statutes.
Out of the
and
statutes, yep.
putting it in your document. Numbering on page 43, page 44, and on page 45 down at reporting procedures B2A.
On 43, you've got an hourly rate that's been added there at section 5.46.
Oh, I'm sorry, yes.
A2.
Hourly rate under section 2D.
Yep.
Then over on 45, the new section, or the old section, employee must report prohibited workplace conduct by reporting it to any supervisor or the county judge as appropriate. And then the language, although all reports will be accepted, a policy discrimination form is available to Human Resources Department for this purpose. That language, that last language has been stricken.
Jeff, what about page 38? Skipped that for some reason. termination.
Oh, okay. Under paragraph
Oh,
4,
yeah.
termination, the county judge, strike the language with fiscal court approval may dismiss an employee. Written notice shall be given to the employee prior to or at the time of termination. And that was done because of your
Right.
process in reviewing it.
Right.
On 46, there's renumbering as well. 47, section 5.51. I think we have two, we have, I read the language for that
Yes.
one to begin with.
Right.
Page 48 is renumbering as well as 49. Page 57, renumbering as well, 58, 59. Page 64, renumbering.
I think beyond 46, page 46 is just the font changes, not the font, but the structure, the pages changes, because you made the changes on the front end. It's going to be consistent all the way through the document.
Oh, okay. What page you say?
I think 46 is the last actual amendment.
Oh, okay.
The
rest of
other,
it is
the
just
other,
numbered.
yeah, the other one is changing the subsections because
Yeah.
of the changes on the front end.
Yeah, and there's sorted renumbering and the rest of that document.
Did you, you covered 2 of the 5 that Jason
No,
and I
I have not
discussed?
gone back on
Oh,
section.
okay. You got 2 of the 5, yeah.
Yeah.
Okay.
I got section 2.6B, which would be .6B, the original language, the county judge shall appoint individuals or to administrative positions and to boards and commissions in writing with the written nomination submitted to the fiscal court. The proposed amended language as submitted, the county judge shall appoint individuals to administrative positions and to boards and commissions in writing with the written nomination stricken, names of the proposed appointees submitted to the fiscal court members in writing at least 1 week prior to the date of that proposed appointment. That is section 2.6B. Section 3.5 on order of business. At each regular meeting of the fiscal, this is the proposed language that we covered today.
Let me interrupt you for a second, Jeff. Going back to that last one. Since that item would be voted on, making it specific to a week before. Some board appointments, you may not, like the cemetery board, trying to find somebody right now for the cemetery board, we've yet to find somebody. There's times where appointments may not be filled because trying to find people to fill them.
I agree.
I mean, that's a very specific and stating shall in that language. I'll just throw that out there. I know that's in a proposed amendment.
I mean, does the language prohibit the fact that it may go over, I mean, it says the proposed appointment, the date of the proposed appointment, not necessarily, in other words, if you don't have an appointment person available, all you have to do, once you identify that person, you can get that name to the fiscal court, and if it's at least a week ahead of the next meeting, then you can vote on. That's really all that I think.
Yeah,
Well, I
I
think
think that's all it says is cemetery board, if you're going to appoint somebody, you may not find anybody for a month or 2
Right.
months, but
that those
when you
names have
find
been
them, you
identified.
get the name to the court, and at least a week later, you appoint them. Is that prohibitive, or is that, to me,
No,
that's
I
what
mean-
that says?
If the thing is, depending on when the court date falls, you may have to wait 2 weeks or
Well,
longer to
It
get them
just says at
appointed.
least a week ahead. It
My,
doesn't say
my
that
thought
it
was,
has to
Jeff,
be.
that prior notification, when we hear the names for the first time in here, you know, we may not know, most of the names we're familiar with, but sometimes we're not, and so we can familiarize ourselves, and if you know, we're making an uninformed decision if we don't sometime. And Jason said you've got to put when we were structuring this, I'm not stuck on a week. I could live with 2 days before, just 2 business days before or whatever, and I understand what the judge is talking about. Some of those boards, you can't find anybody, but the ones some of the ones we appointed last week, you could, and there was a list, and I would just like to have a chance to review the list so I can do my homework.
Well, instead of tying it, I mean, I just throw this out there, instead of tying it up, and, I mean, shall is a very strong word on the front end. If there's names that are presented, the court can table it. I mean, there's options, but putting it in the language to make it specific on the
That's
front
fine,
end.
as long as we table it till we feel comfortable making the
I mean, that's an
decision. I have no
option,
problem with
that's an
that.
option that the court had last time we did it. I mean, I just throw that out there.
So that'd be up to you all.
I mean, I
way
have no
the,
problem. I just like
is
prior
that one that's
notification. When
in
the
the,
names are there, I would
original
like to know
changes?
them.
No,
So that's
That's a
a
new one.
new,
At least
that's
two
the new
amendment.
That's the new proposal.
So that hasn't been read in the first
No, I just.
reading and.
Well, I read it today as a proposal to the second reading of this document, proposed amendment.
So let me make sure I understand. The first reading changes or amendments, this is a new amendment?
And it can be amended up through the second reading.
Okay.
Right.
So so that change is, like I was saying, it's specific on the front end. It is an option for the court to table it if they need more time to research the appointment.
Once you put it on the table,
I mean, once you
It's a-
put it in the language, that's what you got to go by.
yeah.
I'd like when all, if at all possible, to know. I know last time I called Monday and just wanted to know the names, and the names were there, but they weren't released. And I like to have a chance to, you know, if they're there, I understand what the judge is talking about with cemetery boards. Some people don't. You know, it's hard to fill some of those fire districts and so forth, but if at all possible, I think 2 prior business days, and if we don't have somebody by then, I think we'd have the names by then. If the clock was ticking and the board was down to 3 board members instead of 5, I think we're going to, you know, have some names to fill it with. But just in 2 days, I'm not stuck on a week. 2 business days are fine with me, just whatever everybody's comfortable with. Just so that we can take,
Two's fine with me.
not be Justin Lamb, got to do a little research on him, make sure he's okay.
All right, well, the proposal, there's 2 proposals.
To go back on that last one, the statute doesn't state anything, the state statute doesn't state
No.
anything as far as
No
a
limiting
week.
language.
There's no limiting language at all. And I think that the fiscal court, if in fact needs time to review appointments, they've got the authority legislatively to make
All right, and then, you
a
know,
table the option.
they can either vote then or vote later or not
That's
vote at
right.
all, and whatever, depending on what they do, determine the outcome.
Correct.
But if they vote to go ahead and approve and somebody else is uncomfortable, I would think we'd want all of us to be comfortable with the name.
Well, I think
It's
that could happen if you get it a week before, or
It could happen, but it's less likely to.
it could happen either way.
It's a lot less likely to. That's still my proposal that I would like to see in there. And I'm not, like I say, I'm not hung up on a week. 2 days, 2 business days is fine. 1 business day is fine, as long as it's not at 4:29 of Monday before Tuesday's meeting.
Well, I'm gonna go ahead through the other two, and then
Okay.
you all can start voting on them piecemeal or in a
Okay.
whole, or
Damn.
however you want to do it. 3.5, is under section 3.5, order of business. The language as proposed in the first reading is that each regular meeting of the fiscal court and agenda will be presented prior to the meeting. County judge or designee shall be advised of any requests for items to be placed on the agenda no later than 12 p.m. 2 business days prior to the meeting, with approval of the county judge. That's the new language, that with approval of the county judge. Any requests thereafter may be placed on the agenda at the discretion of the county judge or designee. This agenda shall be followed unless dispensed with by a majority vote of the members present. Section, the other proposal, section 3.5, at each regular meeting of the fiscal court, an agenda will be presented prior to the meeting. Strike, county judge or designee shall be advised of any request for items to be placed on the agenda. New language, a request for an item to be placed on the agenda shall be submitted to the county judge or designee no later than 12 p.m. 2 business days prior to the meeting. Any requests thereafter may be placed on the agenda at the discretion of the county judge or designee. This agenda shall be followed unless dispensed with by a majority vote of the members present. You see the two and the differences.
When Jason and I discussed this and the changes, we'd already talked about the travel last time. Just want to make sure that it appeared the way we discussed it. I had just 3 changes or proposals that I would like to see. That was not one of them. And when we were going through my administrative code, I just and highlighted, and I just had a question mark. And Jason said, "What about this?" And I said, "No, I just didn't really understand it." And he read it and he said, "It's not very well written. But what's your change?" I said, "Well, I didn't have a change." And I said, "Until you just now said it's not very well written and not easy to understand." So I thought, well, we best put it where everybody can understand it. And that my feeling there is that the people that ask to be on the agenda that for a reason should have, and Marshall County taxpayers should have the right to speak, freedom of speech right here, and we can't let them sing the national anthem, but every time. But
I see your point, and I'll just be frank. What I see here, or the one thing, is whether or not the judge has any limiting ability to the agenda. The problem you can get into is whether it's intentional or not. If you get 400 recommendations to be on the agenda at 10 o'clock on Thursday, you can't put them all on there.
right, I understand.
And
that.
under this newest proposal, that's what would have to happen.
Well, and the other thing too, there's people that call up that want to be on the agenda when their issues can be resolved, say at the road department. They don't understand that there are department heads that actually can answer those questions for them. So that's my 2 cents.
I'm not concerned with those people at all, and that's great if we can get those and they understand that. But when they show up and they think they're going to be on the agenda, and they followed the rules, they call before Thursday at noon, they show up and they're not on the agenda, which has happened several times. I just want to cover that issue, and unless and they still want to speak, then and their problem hasn't been taken care of. I understand, and that's great if the problem can be taken care of to their satisfaction. But for those who not, it's happened several times in the last 3 or 4 months, and I feel like those people deserve a right to be heard. Sure. But I understand what you're saying too.
You're going to have some limiting,
Right.
at times.
Right.
And, and at times too, there are issues that may have to do with litigation or something that if it comes on the agenda, I'm going to tell you, that's not something.
And that's what you're there for. I have no problem with that kind of thing. And until we have 400 people that do that, and we can amend this at any time, is that not correct?
No, actually, you can't. Only in the month of June, that's,
Well, we review it every June.
you
can't we?
review it, but you can't amend it.
Let me just give you two words that will, if you recall, how, racetrack. You remember? We had the walls lined at times, and everybody wanted to be on the agenda. You had to set special meetings to address those things.
In addition to that language, my office we oftentimes have an idea of the items that we need on the agenda, but they're not necessarily completely prepared until sometimes the morning of the meeting.
Well, yeah, but that's.
No, I don't have any problem with that. I
That's
understand that.
addressed
That's
there.
legit.
That
I'm
don't
just
keep
talking
you-
about the
That don't keep
taxpayer
you from doing that.
that thinks they're going to be on
Yeah.
the agenda and in the audience.
Obviously, anything afternoon on Thursday is strictly within his discretion
Yeah.
regardless.
Sure, I agree with that. That's Emily's point, well taken. I agree 100%.
It's just, everybody the way this is written, anybody that requests can be on there if they put that notice in before noon on Thursday. That might be my only concern.
And it sounds like that this amendment is drafted because of, I think you stated 4 times in the past 3 months.
I'm just,
Some people,
there's several.
and I'm
Like
not
I say,
familiar.
When I sat down with Jason on Friday for an hour and 15 minutes, an hour and a half, that wasn't one of my proposed changes, and he said, well, you've got a question mark by that, and we started talking about it, and he said, well, his comment was that it's not very well written, and I said, he said, do you want to change it or not? I said, well, I didn't have any amendments to that or question on that until he
And we
made
don't
that
have to
comment,
change
and if the county attorney's office makes that comment, I had a little concern that, that it's not very well written. He didn't expound on that, so this is what we came up with.
But then you went on to say that there were 4 times where people didn't get on the agenda.
There has been numerous times. There's been a whole lot more than 4 times over a period of time. But there's people that have been in the audience that thought they were on the agenda. That whether it's a misunderstanding or what, they came back the next week and they were fine, and it's all good, and it got settled and the way it should be. But I just think everybody that wants in, and it's got to be there's got to be some control. But I think everybody that's here to speak, we haven't had that problem. I understand what you're talking about with the racetrack. I wasn't here then, but I've been on similar. We had the same thing with when Marshall County, we were drafting the alcohol ordinance and so forth.
Well, just so that
2015,
the
but they
people
should have
know,
a chance to
the
speak.
communication to my office, the agenda is prepared at my office, and I have communicated.
Well-
I'm trying to see the issue here.
Let's take a step, once I read it again, a request for an item to be placed on the agenda shall be submitted to the county judge. No, it does not say that it has to be.
It don't have to be put on the
No.
agenda.
No,
It
it
just
doesn't.
says, if I'm going to request it, I have to do it.
That's what I was,
Right.
that's what I
So
was
I
trying
I
to
mean,
think
Jason wrote it. That wasn't
Yeah.
even one of my changes. He just
I
thought.
I read it to be more strict, but
I
it's
don't-
really not.
Well,
Okay, well, that's kind of
It-
what I was
and
thinking.
that-
It really
that's
said
the way I
same
read it,
thing.
but when you make comments that people try to get on the agenda and then they don't get on the
I'm just
agenda,
talking, let's
that's-
just talk about this
that's,
right here. My point is, everybody should have a
insinuating-
right to speak.
directly at my office, because I'm the one that does the agenda. Any
No,
clarification
that
on
wasn't the
that?
intent, and I didn't write that. I didn't have a proposed change. That was the assistant
But
county
you
attorney
submitted
that
it.
structured that, and for strictly because, as I stated, in my opinion, and I'm one of 4, I think everybody that asked to speak should be able to speak within reason.
Is it, and I take it that that is your amendments?
That one is not. Jason wrote that, rewrote that one strictly because he said, is that one of your concerns? I said, no, I just didn't understand it. That's why I had a question mark, but that question mark was to myself. And he read it again, and he said, that's not very well written. And I said, well, now I've got a concern if the assistant county attorney says it's not very well written, and that's what he came up with. But that's my intent. What was your last comment, Jeff?
But the other thing is that this administrative code was reviewed by council last year and approved. Actually, it was approved in June 2016.
I understand that. He just,
So,
you change your mind. I guess you look at it with a different set of eyes at a different.
But the
a
voting
period in time,
member-
and that- I'm just telling you
the
the
letter that
comments.
was sent out June 1st were to the elected officials that if they have any amendments, not the county attorney or assistant county attorney.
I'll just tell you, Jason's problem is more grammatical, the way I look
I can
at
see
it,
that.
than it is procedural, because it just throws in with approval of the county judge at the end of the, of the
And you are
proposed-
correct.
That's new proposed language, and I think he just said, rather than do it that way, say it up front, that you place it on there.
Well, it'd be different if it was proposed as a grammatical change instead of people that can't get on the agenda. That's a lot different, and then to say somebody else wrote it. So,
Yeah, that's exactly that's exactly what he said.
I mean, once I read it and reread it, did.
it's almost the same as.
It is.
It's almost the same, exactly.
Exact same
He
thing.
just, that's,
Okay, well, I'm going to move on to the last one, 3.8C. This is a new proposal. The original language is, county ordinances shall be amended by ordinance and only by setting out in full each amended section. The new proposed language, county ordinance shall be amended by ordinance and shall only by setting out in full each amended section, period. Fiscal Court members shall receive a copy of the proposed amendments in required format at least 1 week prior to the first reading. So the only thing there is the notice, or is the handwriting.
just in
1
proper,
week.
it's in proper form, which we did today, and these were.
So,
You want to go through those individually?
the entire one.
Does anybody have any problem with any of them?
Well,
All right. Well, let's see, let me.
it don't matter to me. I can deal with any of them.
Well, all right, I think the only ones that may be in dispute may be the difference in the first reading as proposed and the additional proposed language. So I don't think there anything to dispute, so there isn't, and correct me if I'm wrong, any dispute on anything else that I went through. So I think you can, if you want to address each of these individually and then address the others as a whole, that might be quicker, but I'll do it however you want.
You can do them individually. Or, I mean, as a whole. As long as everybody understands them.
What do you want me to just pick one?
The
Doing
things
them
we
as a
have
whole?
discussed right here are now gospel if we approve.
They're all as part of the second reading.
Right, which
Whatever
they,
when you all vote, it'd be what language you've
Be
adopted.
the
That we
second
just went
reading, or
over.
it'll be the second reading as amended.
yeah, and we'll include
Well,
these.
Okay, yeah, second reading as, because you have the first reading that I went over first, then that'd be the second reading as amended.
Second reading of the amendments.
That includes these. Okay, got you.
It just depends on what language you adopt, and starting with section 2.6B. That is the section where it was suggested at least 1 week notice on board appointments.
He said as a whole, I agree. Just approve them all.
Well,
That was consensus. That's what the judge just said.
are you all wanting to leave that language as proposed originally or as proposed now?
I asked.
Proposed now.
Okay, with requiring 1 week's notice of proposed appointments. So what I would say.
Either one, 2 business days or 1, it doesn't matter.
Oh, we
Whatever
got
you
Say
want.
so.
It does matter because it's going to affect my office.
Need
Okay,
to
which
say.
would you prefer, the week or the 2 days?
I would prefer that if you can't make your mind up, you table the appointment.
I would
that'd make
prefer
it
the
easier.
2 days or the week myself. I just think we now need prior notice,
Because there's,
so we won't get shut out.
excuse me?
comment.
If you look at the statute is clear that the judge executive makes the appointments, the fiscal court approves it. I've been following that statute.
That's the reason I had you clarify the other day, just to make sure, because the statute basically
Yes.
provides a nomination, and then for them to vote on that nomination. And
Yes.
we get away from that sometimes, and then when we get into one that's contested, then it
Correct.
falls back on me.
Correct.
I just want to make sure the record's always clear.
That's fine, 2 business days. 1 business day would be okay. This is why I called Monday for Tuesday's things, and the list was there, but I didn't receive that list.
Who'd you call?
She'll raise her hand, she'll be recognized by the camera.
Who had the list?
I guess the judge's office, I called the judge's secretary and said the judge did not give me
I had the list.
Okay, well, that's the judge's office. You can communicate, and that's usually the way.
But again, the statute says that the appointments are made to the fiscal court on the agenda. I mean, from what I'm understanding is that the appointments were made, you must have had a problem with one of the appointments.
I did
and
not
the
have,
phys-
I didn't
and
know
the
whether I
fiscal
had a
court-
problem because I didn't know
the
what the
fiscal
names were,
court,
nor did I have a time to do my due diligence
The
and find
fiscal
out.
court voted on that. It doesn't say that Commissioner Koch votes on it. It's the fiscal court. Now, if you had a problem with one, you speak up and you say, can we table this? I'd like to further find out about this individual. But as far as the procedural and statute, it was followed.
But if there is no problem and I'm the only one that wants to table it, it doesn't get tabled. And so my chance to review those candidates and find out something, and that certainly wasn't a problem the other day. But like I say, I think this body, if we're going to be voting on something and those names are known, and that we could be provided those lists so that we
But-
would have time to do due diligence.
And like I was saying, we've done this for 3 years, following the statute. It's your responsibility to bring it up under discussion if you don't know somebody that's being appointed. I mean, that is your responsibility. And if
That's just
if you don't bring that up,
One suggestion.
then that's on you. But to sit there and say 2 days before, that puts it back on my office. I could be on vacation. I mean, there's a lot of things that can happen
If you're on
at
vacation,
my office.
Just delay it until you're, got 2 days to inform this body. I just want to be able to make educated, well-informed decisions and have the time to do so. And that's the only reason I propose that. Now, I still, like I say, I don't have any problem changing the week to 2 days or 1 day. I would prefer it be at least 2 days, really, but I'm not hung up on the week. That's just like my recommendation. There's 4 people this side. I can live with it.
So you all will need to, someone will need to make a motion to propose
So moved as read.
under the newest
Wait,
proposed
let's
section. There's only one
that.
proposal for section 2.61B that would change anything in the original.
Right, and
Administrative code.
my motion is instead of a week to make it easier on whoever or all of us, or I'll make a motion, instead of a week, we strike the week and make 2 days. That's sufficient time for me.
Business day.
2 business days, as corrected, Commissioner Go.
All right, you all,
Second.
you have the language for proposed to,
From 1 week to 2 days.
Are
You-
you doing them individually or as a whole?
yeah.
Yep.
So that would need to be in a motion.
I think I heard
That
first and a
was
second.
a motion for 2 days and a second.
Yep, 2 days is the new language.
2 business days.
2 business
Bob
days.
said. Okay.
There's a first and a second, Bob.
Yeah, we first,
Johnny?
I made the motion, it's already been first and second.
Johnny? Rick?
Aye.
Motion carries.
All right. Now, back to this language in section 3.5 about the items being on the agenda. The recommended language in the first reading with approval of the county judge, and then the language is proposed, as Jason reviewed, and like I say, it appears to me to be a grammatical request more so than anything else from his standpoint. But you have two sets of language there available as proposed at this point, or do nothing at all.
My motion is to go with, as Assistant County Attorney Jason Darnold worded it, and I think you're right, that was his intent, and if he's comfortable, I'm comfortable.
Second.
There's a second. All those in favor, Bob?
Aye.
Johnny? Rick?
Aye.
Motion carries.
Section 3.8C, there were no recommendations in the original proposal at the first reading. The new language adds fiscal court members shall receive a copy of the proposed amendments and required format at least 1 week prior to the first reading. That's on county ordinances.
So moved.
Second.
There's a second. All those in favor, Bob?
Aye.
Johnny?
Aye.
Rick?
Aye.
Motion carries.
Section 4.1A, the language as presented at the first reading included assistant treasurer. The newest proposal reads as follows: the annual budget preparation process shall be administered by a budget committee consisting of the county judge, county treasurer, assistant treasurer, deputy judge executive, and/or county administrator, county attorney, and one commissioner as elected by the fiscal court, with the county judge breaking a tie vote if necessary. That's the new proposed language.
Motion to approve.
Second.
Let me point out that that group is not, there's no authority. This is the judge's budget.
It's his draft.
Right, I mean, yeah, the draft. And what I'm getting at is, there's not a vote taken by that committee to do anything.
Right.
The judge it's, the budget's discussed. I address the legal issues as they come up. And that is, I wanted to make sure the structure, or my understanding of that structure of that group is known.
I just think it makes it easier, that with that amendment, that makes it easier for communication to exist, and we need to have every opportunity to communicate the issues.
I think the statute stands alone as far as the, what's governing the judge executive to present a budget to the fiscal court.
Yeah, May 1st, my amendment to administrative code.
It's something that,
I would like to see a commissioner on
has
there.
been
and it
done
says
for years.
If it's a 2-2 tie, the county judge breaks it and he chooses the commissioner.
Oh, there's no vote on that.
Well, and
That-
two, the process that's used is whatever, if he came up with that document and just gave out those people, asked for those people's input before he brought it here. I mean, there's nothing that requires him to sit down with those individuals and go through it line by line. You agree with that, Judge?
I do agree with it.
Okay.
I don't understand the tie vote, whatever that language is
Well-
that's written in there.
That language, that is actually, if this is appointment to a formal some kind of formal agency of the county, then there's a statute that covers that.
Yeah. And
And it
that'll-
appears to be that an attempt to include that language as part of this process.
Yeah, I don't agree with that. The budget, the way we've been doing the budget has worked. It doesn't matter if it's in the administrative code that I use, just like what you were saying, if I use a committee or a group of individuals to sit down and review it. But as far as putting an actual formal process on it, the fiscal court is the formal process of it.
I'll be honest, before you came along, I never saw a budget before it got here. There was no process that I'm aware of.
Well, and
way I
my problem
understood it.
is the format has changed from last year to this year. We had
Hang on, let me
six
ask you.
budget workshops with all the department heads that all of us saw their proposed lists and so forth. Every voting member of this body saw that. Three of the four of us that vote on that did not see the
I
department
know,
heads.
but I'd be honest
That's-
with you, I
that's my
don't
problem.
think this change would affect that.
Yeah,
If he chooses to do it himself and just submit it to those, if you name this group, all he's got to do is give them you a copy and say, give me your input.
and if you look at.
If that's your legal opinion, I have no problem. I
if
want to
you-
do it
He
legally.
never has talked with you.
If you
me or
look at
anybody else.
if you look at the statute, when you say format,
you.
the only legal format, if you will, is in the statute, section 2.
I've got
And it
that.
outlines how this budget is to be outlined. That's the only format that is mentioned in a statute. And we have done that. That's the way it's been presented. That hadn't even been changed. That's the same format because it fits the statute. So when
And
you
that-
say
they can't-
format, you're obviously
Technically,
not,
Judge, they can't change that.
no, they
They can
can't.
only change the amounts that go in it.
Correct.
I have no problem on your legal recommendation. I have no problem. I
But
understand.
I want to be clear because there's people sitting
We-
at home. When
we
you say
we
format,
understand.
there is only one format, and we have been in compliance with that format, and that's the state law.
I didn't say that. I just had a recommendation on there. Legal representation, I
When
understand
you
what he's
say
saying.
the format
I
changed
understand what
last
he's saying,
year,
and I have no problem
You
with that.
do, well, you said the format changed last year. The format did not change last year. It's state law, we follow it.
The discussion afterwards, I guess maybe I should restate, in between the first and the second reading, and the lack of discussion this time amongst the four of us that vote, and the opportunity we have, and the only forum available to us was probably cut down to a tenth of what it was last year,
And
we have to be able to communicate and discuss.
And the same statute outlines that as well. It states meeting or meetings. So again, there's no change. It's state law. Everything that we have done, we are following the law.
We just didn't
And you
understand
can-
why we got to
you
meet
can
with the
pull up
department
that-
heads last year, and we didn't this year.
This law has been in place
didn't
way
do
before I got here, and we've been following it. So I can't help that we're following the statute.
Want to repeat that again?
But to make it specific to that amendment,
We didn't follow the statutes last year then when we met with the department heads,
yes, we did.
so why didn't we this year?
It's the same statute. It says meeting or meetings, but you're saying that
You
the
wanted
format
meeting,
changed.
we wanted meetings.
But the form,
And
what I'm stating is
Virtually,
we
we're
went,
having meetings.
we went by the statute. When you say that the things had changed, the statute did not change.
I didn't say the statute changed, just how
We followed
it
the
applied
statute.
to us apparently changed.
But pertaining to that one,
We're all
as you
agreeing, legal
stated,
advice, let's
Jeff,
move on.
as far as that language, if it's insinuating that there is a committee or an organized
It's only an
voting-
advisory group, is what it is, technically,
We
because
all
there is no
understand that
authority.
through legal advice.
Right.
Well, it's in the administrative code now, it says it's a committee.
I know, but as far as having it, that's the reason I wanted to make sure clarified. If when I think about a committee, I think of a group like this, and something comes up and you vote on it. That's not the case.
And I think the statute supersedes that word
Oh,
committee.
I know, it does,
Yeah.
it does. You can't change, yeah, that's what I'm telling you, if he's so, he can qualify under this section as you put it in here and never talk to any of us.
We
placed it
all
with-
understood that 10 minutes ago with your explanation, and I'm satisfied with it.
We placed it in,
I understand.
Me too.
You're not criticizing me for repeating something, are you?
No, I'm
Please.
certainly not. I'm certainly not. I understood, and I've said, I guess the other commissioners, but we can move on as far as I'm
Okay.
concerned. I'll take your
Well, I
legal
won't say it
opinion,
again.
and I understand what you said.
Just quit repeating yourself.
So is there a motion?
Yeah.
Second?
Already had a motion and a second.
All those in favor, Bob? Johnny?
Aye.
Rick? Motion carries.
All right, and finally, on section 5.51A3,
I thought that had already been resolved.
yeah,
Yes.
yeah, that would be the one thing that we've agreed on. But I'll be honest with you, that last sentence in it basically doesn't, if you're going to put that in there, you don't need even the policy. I mean, it's strictly choice.
Well, that's what we
Right.
discussed.
Okay.
today.
That's what we wanted.
The department heads could encourage everyone to.
That was
to
just the
follow
way it was written last
do
year.
Okay,
that.
so it's suggested language.
Yeah.
I mean, suggested.
Yeah,
language.
that was
So,
what,
in order, now, I'll make sure we're cleaned up. You need to vote on that one.
Motion to approve section 551A3.
it's written here.
As proposed.
Second?
And there's a second. Under discussion, I think the one thing that we left out is that the opportunity to save taxpayers' money with the way it was written. But all those in favor say aye.
Aye.
Any opposed? Motion carries.
All right. And then, all the other proposed changes that we went through, you've addressed the ones that were in dispute. Everything else, I believe, is agreed upon as well. So you need a motion.
Motion to
You
approve.
now have your second reading in place, and you can vote to amend, to approve the administrative code as amended.
That would be so moved. Approve the administrative code as amended.
Second.
All those in favor say aye. Any opposed? Motion carries.
All right.
Is there a motion to adjourn?
So moved.
Second.
In favor say aye.
Aye.
Opposed? Motion carries.